And we are live. Good morning, or whenever you're watching this. This is the last day of the year, so I think it will be my last video. Thank you if you have been along for the ride, and if you haven't been, then thank you for being here today. And if you want to join up, just subscribe. I don't think I ask people to subscribe that often, so subscribe. Get your friends to subscribe. Your pets to subscribe. Both my dogs have subscriptions, and they watch furiously. Like, subscribe, whatever else. Comment. Yeah, comment, please. I appreciate the comments, and do look at. Honestly, I do look at every single one and try to indicate that I've looked at it or comment back. So this morning I wanted to talk about, because I saw a little bit of Twitter talk about discovery. So I wanted to talk about that. I was going to briefly talk about TradeStation and briefly talk about MMTLP arbitration. So those three kind of things. I'll try to do it fast. Before I do that, in two sets. So I'm going to give you today's subject matter are con men, because we deal in that field a lot. So we're talking about shorts that are engaging in illegal acts, in our opinion. By the way, not legal advice. Don't rely upon anything that's said here today. Not a securities expert. Um, but anyway, we deal with a lot of the, I would say, con men in a lot of these transactions. It appears. So today's jokes will be directed at con men, and I'm going to do three up front and two on the end. So, and by the way, one of the last ones is the only joke I think that I've done about a nymphomaniac. So you might want to stay tuned for that at the end. But before we get to the end, let's start at the beginning. So, why do ghosts make terrible fraudsters? Because you can see right through them, of course. And what did the con artist, say about his old tent? This is original con tent. And last but not least, in this first bracket, so and think about this, and I'll let you kind of figure this out amongst yourselves. If you could discuss it amongst yourselves, please do so. So if the opposite of pro is con, what is the opposite of progress? Think about that one. So I saw some tweets and some discussion involving MMTLP, and it's about discovery. And I think somebody asked me directly why I was pursuing discovery. And let me first establish what discovery is. So I do civil law litigation. I've done many trials, etc. I'm very familiar with the litigation process. So discovery is used for really a few purposes. One, it's used to ascertain the facts behind the other party's claims or defenses. So in this case, let's say the fidelity case, I'm the plaintiff, I'm the claimant, I'm the one making the claims. So in discovery, if this were a civil case, I would be entitled to obtain information about Fidelity's or scumbags' defenses, and that's what I could do, and they could do the same for me. So that's one aspect. So you kind of develop an understanding of what the other party's claims and facts are. But number two, you also can use that to develop your own case. So you could use discovery to establish or ascertain facts about your own case. So, in the MMTLP situation, since all the information's been suppressed, it's been difficult to have a 100% case before you start, which is, by the way, that's typical. So discovery is used to fill in the blanks, to understand all the facts, etc. And what's interesting in my arbitration, going back to the first part where I said that discovery is used to figure out what the other side's claims and defenses are, attached to Fidelity's answer to my claim was the article by the Forbes writer Brandon Kay. So they made that a part of their answer. So as such, I asked for their deposition. So ordinarily, in a civil case, I'd be able to get that no problem. In a arbitration, you need special circumstances or extraordinary circumstances. Our extraordinary circumstances are the U3 halt, which by definition require extraordinary circumstances. So that's the justification for being able to depose Brandon Kay. And that would be an element of discovery. So we have the two things. One is to kind of figure out what the other side's doing. Two, to help with your case. And three, when you're deposing the other side, to the extent they testify in a way that is advantageous to your case, you can just read that testimony in at trial. Doesn't have to be discussed. You just read it in from the record. So you actually could use the other party's testimony as part of your case. And so discovery is used for that. And in discovery in civil cases, that's what you do. Generally, there's no need to make a motion for anything. You just propound a certain element of discovery. And discovery doesn't have to be relevant to be discoverable. So, the standard is one, discoverable. So that would be relevancy, or could lead to discoverable evidence. So that's the example of that would be, if I knew the name of someone and that person knew the name of a witness, I'd be entitled in a civil case to obtain the name of the person who knew the name and contact information of the witness. Of course, there's other kinds of evidence that is just directly relevant. If you have a contract, a dispute about a contract, the contract itself is relevant, and communications about the contract would be relevant, and all that would be discoverable. But you can go outside of that. So that's the standard. It's not just relevancy, it's one step removed and easier than relevancy in a civil case. And again, in a Finra arbitration, it has to be extraordinary circumstances, which again, and again, the Finra made the assertion, but by their assertion of the U3 halt, by definition in the rules and regulations, that requires extraordinary circumstances. So before I get into that, how that plays in, there's basically four ways of getting discovery. You can do written questions, which are called interrogatories. Request for production of documents, which is a list of categories and asking the other side to produce records. There's requests for admissions where there's statements made or documents attached, and you're requesting the other side to admit to the authenticity or accuracy of either. Now, the first three things I mentioned all are forms of discovery, will yield information, but they're heavily influenced by attorneys because attorneys can participate in blind and assist in the preparation. So the responses are usually very narrowly crafted, and objections could be asserted, and they could really be subdued for use. But they are useful. But those are three kinds. And the fourth kind is a fourth normal, and there are other ways of getting discovery, but I'm giving you basically the four most common are depositions. And deposition is a questioning under penalty of perjury that's done live. Now, it used to be done only in person, but over time, the fact of doing video depositions has arisen. But the person's under penalty of perjury. They can have an attorney there, but the ability of the attorney to interfere is lessened than the other forms of discovery. That's why it makes it so important, and you get much more interesting information than you would in the other forms of discovery. Sometimes people misspeak. Sometimes people give you evidence that supports your case. Sometimes they lead you to other evidence. So it's really important. And that's why I wanted, for example, wanted to take Brandon Kay's deposition. By the way, I asked him to do it. He declined. But that's why I want to take his deposition along with, and none of this is private. That's why I'm talking about it, by the way. Besides Brandon, I was interested in like Sam Drady, somebody from Finra who was involved in December of 2022, who was involved with the blue sheeting, the fraud reports prior to my purchase of Mmtlp stock. So that's kind of stuff that I can do. And I have a list, I think, of 12 people I wanted to depose, all of them related to Mmtlp. So again, the standard I indicated before, relevancy or could lead to discoverable evidence. And I'm talking about relevancy. These are all witnesses or, and if you're a factual witness, if you have information about what went on, you'd be normally referred to as a percipient witness because you perceived the events. So I think there might be 12 percipient witnesses whose depositions I sought in addition to the ones I just mentioned, the author whose article is attached to the answer of Fidelity, as well as Sam Drady, and Patricia Casamates, if that's the way you pronounce her name. Those are three, for example, all who were involved with Mmtlp. So all the witnesses I've requested are all involved. So in a normal case, I would just use those tools. If I wanted to take depositions, I'd send out notices of depositions if they were part of the party. So if I'm trying to take a deposition of a party in a case, I don't have to get a subpoena. I just send out a notice. If it's a third party, I have to get a subpoena, and I would get the subpoena through the Finra arbitration jokers. I use that as lovingly as I can assert, but it's no problem. It's done. And if they don't appear, then you have the ability to enforce the non-appearance through a court order, and you get sanctions, and so be it. And if it's the other party that's being unhelpful in discovery and not appearing, you can get sanctions just beyond monetary sanctions. You can either get issue sanctions, you can get evidentiary sanctions, and you can get terminating sanctions, where in essence you can get a case to be over in your favor if somebody's not cooperative. So there's quite a bit of power that exists to enforce discovery. That's obviously not the case before Finra. So I requested all the discovery that's relevant, besides could lead to discoverable evidence. Because of the U3 halt and extraordinary circumstances, filed numerous motions. The panel, who I've never, by the way, in total have approved or accepted, and who I've asked to be recused before. Recused means, in a legal term, to get out of there, remove, which was denied. But the motions regarding special discovery, all of them were denied without a hearing and without any reasoning. So I was offended by that. In light of the complexity of these questions and the lack of what I thought was super sophistication of the arbitration panel, who I did not consent to in total, I thought a hearing at least would be appropriate to understand this mess, this morass that was created by hedge funds and broker dealers. Yet they didn't deem that appropriate or necessary, nor deem it appropriate or necessary to tell me any reason for why they ruled as they did. Since I had concerns about the panel originally, in light of that action, I sought their removal. So I've, about 2.5 weeks ago, filed a request for their removal, their recusal. Now that goes back to the panel, so we'll see how much movement I get. And about a week ago, I filed a request for the director to remove the panel directly. The director has the authority under the Finra rules to do that. Depends on when you request. I was asking basically for reconsideration of my initial request to him based upon the fact that I thought the panel was shown to be incompetent or prejudged this matter or biased or otherwise, but not appropriate to continue in their position as arbiters. So that's pending. I'm waiting for the ruling on the recusal motion. I'm waiting for a response from the director. Ironically, on January 3rd, 2024, we being Fidelity, who I heard, by the way, a rumor that they're going to change their names to scumbags. That'll be their new name. That was just a rumor. Not sure if it's true or not. But Counsel for Fidelity and I have a joint report that's due January 3rd in the federal court. I've already indicated to the Counsel for Scumbags that I will be filing a supplemental and separate report to communicate my concerns about what is going on in this. And I thought, what's a good name of what is being conducted? So I decided, how about a sharbitration, a shambitration, or a shamitration? There we go. One of those, because that's what's going on. And we shall see. So I have multiple requests out. I'm going to be submitting a report to the federal court. I'm not going to advise you right today what's going to be in that report, but you can imagine, and I certainly will tell you what's in it after it's filed. And I'm sure Fidelity, or whatever their name is, will be filing their own supplemental report in response and claiming there's nothing here, nothing there. I'll also be including, I probably, is the congressional letter and the trade station. Oh, trade station. Let me briefly talk about that. And I'll do probably a separate video on this at some point in time. Trade station. So I saw that they admitted or acknowledged or something that they don't have enough shares to transfer to AST. I think they were like 2/3 short. So that means there may be 200% of counterfeit shares if everybody else ran the same. But my point was, if they've acknowledged a diluted position for their shareholders, that means everybody's position is diluted just by those particular shares. In other words, if there should be, and I'm just going to use numbers, if I bought shares and there should be 100 shares, but because of what TradeStation did, there's 102, I have a smaller interest in the company. So I've been impacted. And what Fidelity sold me, whatever that nonsense was less than one share, because they couldn't sell me a full share because that wasn't possible. And that presumes that nobody else is counterfeiting, which we all know that, you can only imagine the counterfeiting. So I believe what's of interest to me is this trade station issue will be in front of my federal judge on the 3rd or sometime after the 3rd, and he will be made aware of the counterfeiting. And also I will be filing something with my arbitration to put them on notice of that also, just so there's a record, so that if in fact we go get a result in the arbitration that we don't like, there'll be a full record when it goes up to the district court to be affirmed or vacated. And depending on how that goes, there will be a full and complete record to go up on appeal, which might be, not a bad way of going, depending on how things proceed, because an appeal would be precedent for the outcome. And if the outcome was good, that would be fine. So the record is being made. And we shall see how and where it goes. But that's the trade station part. Indicated that as soon as I file the report, I'll let you know. And I think I covered that. So we talked about discovery, what it's used for, the benefit of depositions, and the absence of attorneys. We talked about a little bit about trade station, talked about my arbitration, what I'm trying to do, and where we're at. And to leave you, as I said, I didn't want to let you go without two more on the way out. Never trust people who sketch facial composites for police reports. They are con artists. And last but not least, because I promised this one, did you hear about the nymphomaniac con artist? She screws everyone. Anyway, I hope everybody has a happy and healthy end to the year. Be well, take care, keep up the fight, and next year we will be battling. Take care, be well, and let me get out of here.